There are a lot of videos about copyright law on YouTube. Some of them are made by lawyers who talk like they're billing you by the hour. Some of them cover one tiny piece and leave out everything else. And almost all of them were made before the Supreme Court rewrote the rules on fair use, and before AI turned the entire system upside down. This isn't one of those videos. In the next 20 minutes, I'm going to take you through all of copyright law, what it protects, how it starts, how long it lasts, what fair use actually means after the Warhol decision, how enforcement really works, and why artificial intelligence is forcing the biggest copyright question since the printing press. No jargon, no law degree required, just stories, real cases, and one absolutely insane fact about the song Happy Birthday that's going to make you rethink everything you thought you knew about who owns what. Let's go. Here's something that's going to bother you. Until 2016, if you were making a movie and you wanted a character to sing Happy Birthday in a scene, you had to pay for it, not a little. We're talking thousands of dollars. A music publishing company called Chappell was collecting more than $2 million a year in licensing fees for a 16-word song that was written in 1893 by two kindergarten teachers in Kentucky. $2 million a year. For a song your grandmother sang to you when you were 3. And the wildest part? It turned out they didn't even own it. A judge looked at the original copyright registration from 1935, held it up, and said this covers a piano arrangement, not the lyrics. You've been charging people for something you never had the rights to. $14 million in refunds later, Happy Birthday was free. How is that possible? How does a corporation end up owning a song that belongs to everyone? How does a 16-word melody generate more revenue per year than most musicians make in a lifetime? And how did nobody challenge it for 80 years? The answer is copyright. And I'm willing to bet that almost everything you think you know about it is either incomplete or flat out wrong. So here's what we're going to do. I'm going to walk you through the entire system of copyright law, start to finish, using stories instead of jargon. And by the end, you'll understand not just what copyright is, but how it shapes almost every piece of content you consume, create, or share. Every video you watch, every song you stream, every photo you post, every email you send, all of it runs on copyright. And almost nobody understands how it actually works. Let's start with the most basic question, and honestly the one that trips up most people, including me the first time I studied this. What does copyright actually protect? Here's the trap. Most people think copyright protects ideas. It doesn't. Copyright protects expression. The specific way you express an idea, not the idea itself. Let me show you what I mean. Picture two novelists. Let's call them Sam and Alex. Sam writes a novel about a young wizard who discovers he has magical powers and goes to a secret school. Alex, completely independently, also writes a novel about a young wizard who discovers he has magical powers and goes to a secret school. Same idea. Two totally different books, different characters, different dialogue, different worlds. Both of them have full copyright protection. Neither one is infringing on the other. The idea of a wizard school doesn't belong to anyone. But the specific sentences, the specific characters, the specific scenes, that's expression. That's what copyright covers. This is called the idea-expression dichotomy, which is just a fancy way of saying you can't own a concept, but you can own the way you put that concept into words, images, music, or code. And once you understand this, a huge amount of copyright law starts to make sense. You can't copyright the idea of a love song, but you can copyright the specific melody, the specific lyrics, the specific arrangement that makes your love song yours. That's the first click. Copyright doesn't protect what you think, it protects how you say it. Now here's where it gets interesting. How does copyright actually start? Like, what do you have to do to get it? Nothing. I'm serious. You don't have to file anything. You don't have to register anything. You don't have to put a little copyright symbol on it. You don't have to mail yourself a copy. You don't have to pay a fee. The moment you create an original work and fix it in some tangible form, you write it down, you record it, you save it to a file, copyright exists. Automatically, by operation of law. That email you sent this morning, copyrighted. That doodle you drew in the margin of your notebook during a meeting, copyrighted. That photo you took of your lunch and posted on Instagram, copyrighted. You are a copyright holder right now, today, for dozens of things you probably never thought about. Wait, stop. Read that again. You already own copyrights. You just didn't know it. Now you can register your copyright with the United States Copyright Office, and there are real advantages to doing that. Registration creates a public record. It lets you sue for statutory damages and attorney's fees if someone infringes. It's like locking your front door versus having a security system. The house is yours either way, but one gives you a lot more protection if someone breaks in. But the core right? It's already yours. It's been yours since the moment you created the work. This blows people's minds, and honestly, it should. We walk around creating copyrighted material every single day without thinking about it. The system is running in the background of your entire creative life, whether you know it or not. Now let me take you to the part that made Happy Birthday such a mess. How long does copyright last? And why does it last so long? Here's the current rule in the United States. For anything created by an individual after January 1st, 1978, copyright lasts for the life of the author plus 70 years. Let me say that again. Life plus 70. If you write a book at age 30 and you live to 80, that book is protected for 120 years after you wrote it. Your grandchildren's grandchildren will still be managing the rights to your work. For works made for hire, meaning something a company paid someone to create, it's 95 years from publication or 120 years from creation, whichever comes first. Why is it so long? There's a whole rabbit hole here that I'm not going to drag you into today, but the short version involves a mouse. In the 1990s, Disney's copyright on the original Steamboat Willie version of Mickey Mouse was about to expire. Disney lobbied Congress hard, and in 1998, Congress passed what critics called the Mickey Mouse Protection Act, officially the Copyright Term Extension Act, which added 20 years to existing copyright terms. That pushed Steamboat Willie's expiration to 2024, when it finally entered the public domain. That's wild when you think about it. One company's desire to keep a cartoon mouse out of the public domain changed the copyright term for every single work in the entire country. And this is exactly what happened with Happy Birthday. The song was written in 1893. The melody was published as Good Morning to All in a book of kindergarten songs. Somewhere along the way, the Happy Birthday lyrics got attached to that melody. In 1935, a company registered a copyright that covered a specific piano arrangement of the song. Years later, Warner Chappell acquired that company and started collecting fees from anyone who used Happy Birthday commercially. Movies, TV shows, restaurants, anyone. For decades, nobody questioned it. And here's the thing that still gets me. When a judge finally looked at the actual registration in 2015, it was clear. The 1935 copyright covered the piano arrangement, not the lyrics. The lyrics had likely entered the public domain no later than 1921, when they appeared in print without a proper copyright notice. For the better part of a century, a corporation was charging money for rights it didn't have. And people paid. Because who's going to hire a lawyer over Happy Birthday? I know. I had the same reaction. Quick pause. Let that sink in before we move on. Because this next part is where things get genuinely complicated, and I want to be upfront. Fair use confuses everyone. Law professors argue about it. Federal judges disagree about it. I've read the statute multiple times, and I still have to think carefully every time I apply it. So if your head is spinning by the end of this section, you're not alone. Mine spins too. Fair use is a defense, not a right, not a permission. A defense. That distinction matters enormously. It means you don't know if something is fair use until a court tells you it is. You can believe it's fair use. You can be pretty sure it's fair use. But if someone sues you, you have to prove it. And the way you prove it is by running your use through 4 factors that Congress laid out in the Copyright Act. Factor 1. The purpose and character of your use. Are you using the work for something new, criticism, commentary, education, parody, or are you just copying it for the same purpose it originally served? And is your use commercial or non-profit? Factor 2. The nature of the copyrighted work. Is it a factual work or a creative one? Using material from a news article is more likely to be fair than using material from a novel. Factor 3. How much of the original did you use? A sentence might be fine. An entire chapter probably isn't. But there's no magic number, no percentage rule, no 30% and you're safe. That's a myth. Factor 4. The effect on the market. Does your use hurt the copyright holder's ability to make money from their work? This one is often the most important. Here's what makes this hard. No single factor is decisive. A court weighs all 4 together, case by case, and reasonable judges can reach opposite conclusions on the same set of facts. In 2023, the Supreme Court made this even more complicated. A photographer named Goldsmith took a portrait of Prince in 1981. She licensed it to Vanity Fair, who hired Andy Warhol to create an illustration based on it. Warhol made a series of prints. After Prince died, the Warhol Foundation licensed one of those prints to a magazine. Goldsmith sued. The Supreme Court, 7-2, said that wasn't fair use. The Warhol print served the same commercial purpose as Goldsmith's photograph, illustrating a magazine story about Prince. And the foundation was making money from it. The fact that Warhol was a genius and his print looked very different from the photo wasn't enough. That decision sent a shockwave through the creative world because it narrowed what counts as transformative. Before Warhol, a lot of artists and creators assumed that if you changed a work enough, if you added new meaning, new expression, you were probably safe. After Warhol, the question isn't just whether you transformed the work, it's whether your use competes in the same market as the original. And if it does, you've got a problem. Picture this. It's a Friday night. Alex, a small YouTube creator with maybe 10,000 subscribers, posts a video essay analyzing a popular movie. He uses about 90 seconds of clips from the film. On Saturday morning, he wakes up to find his video has been hit with a DMCA takedown. It's gone. No warning, no hearing, no judge. Just gone. He can file a counter notification, which basically says, "I believe this is fair use. Please put my video back up." But that takes 10 to 14 business days, and the copyright holder can still sue him. So Alex has to decide, do I fight this, spend months or years in legal limbo, and maybe thousands of dollars on a lawyer? Or do I just take the loss and move on? Most people take the loss. That's the reality of copyright enforcement in the internet age. The system is designed to be fast and aggressive. Take down first, ask questions later. The Digital Millennium Copyright Act, the DMCA, gives platforms legal protection if they remove content quickly when a copyright holder complains. So, platforms are incentivized to remove first and sort it out later, which means the person filing the complaint has enormous power and the person being accused has to fight uphill. I'm not going to pretend this system is elegant. There's something deeply weird about a framework where the accusation is instant, but the defense takes weeks. That tension between protecting creators and not crushing other creators is one of the hardest problems in copyright law, and honestly, nobody has solved it well. Now, stay with me, because this last section is about the future, and it's the part that nobody saw coming. In 2018, A computer scientist named Stephen Thaler created a piece of visual art. He didn't paint it. He didn't draw it. He didn't give specific instructions to a human artist. He used an artificial intelligence system he built called Davis, and the system generated an image autonomously. Thaler applied to register the copyright. He was honest about it. He listed the AI as the author. The Copyright Office said no. Human authorship is required. Thaler sued. He lost in district court. He lost on appeal. In March of 2026, the Supreme Court declined to hear the case. End of the road. That's the current state of copyright law in America. A machine can write a symphony, paint a portrait, draft a novel, and generate code. But it can't be an author. Copyright requires a human. If you use AI as a tool, if you select, edit, curate, and meaningfully direct what the AI produces, the human parts of that work might be protectable. But if the AI does it all on its own, there's no copyright, no protection. Anyone can use it. Think about what that means. Right now, companies are using AI to generate millions of images, thousands of articles, entire libraries of content. And if that content has no human author, it has no copyright. It belongs to everyone and no one. We're creating more content than at any point in human history, and a growing share of it might live in a legal no man's land. And here's the other side. Some of the biggest copyright lawsuits happening right now are about whether AI companies violated copyright by training their models on protected works in the first place. The New York Times sued OpenAI. Music publishers sued over AI-generated content. Authors sued Meta. The central question: is training an AI model on copyrighted books, articles, and music fair use? Hasn't been definitively answered yet. Courts are still working through it. This could take years, and the answer will reshape not just copyright law, but the entire creative economy. If you're still here, you're already ahead of 90% of people who've tried to learn this. So let me pull it all together. Copyright is a system built on a beautiful tension. On one side, you have creators who need protection. The photographer, the songwriter, the novelist, the filmmaker who poured years into a work and deserves to control how it's used and to be compensated for it. On the other side, you have society, which needs access. The student who wants to quote a paragraph in a paper, the comedian who wants to parody a song, the journalist who needs to show a clip to report on it. Copyright tries to balance these two needs, and the fact that it mostly works, even imperfectly, even messily, is honestly one of the most underappreciated achievements of the legal system. The structure of copyright is almost invisible, and that's what makes it so powerful. You don't see it working. You just see the music, the movies, the books, the art. But behind every single one of them is a framework that says, this person made something, and for a long time, they get to decide what happens to it. Before we wrap up, let me clear up 3 things that almost everybody gets wrong. First, you don't need to register to have copyright. It's automatic. Registration helps if you need to go to court, but the right is already yours. Second, there's no percentage rule for fair use. Not 10%, not 20%, not 30%. That doesn't exist. Fair use is a 4-factor balancing test applied case by case. Every state and every fact pattern is different. What you just learned is the framework, not the answer. Third, if there's no copyright symbol on something, that doesn't mean it's free to use. Since 1989, the copyright notice hasn't been required in the United States. Assume everything you find online is protected unless you have specific reason to believe otherwise. Here's what I want you to take away. 1. Copyright protects expression, not ideas. The way you say something, not what you say. 2. Fair use isn't a permission slip. It's a legal defense you have to prove, and it got harder after the Warhol decision in 2023. 3. We're living through the biggest copyright question since the printing press. Can a machine be an author? The Supreme Court just said no. But the questions around AI and copyright are far from settled. If you want to go deeper, look up Lawrence Lessig's Free Culture. It's one of the clearest books ever written about why copyright matters and what happens when it goes too far. And if the Warhol case fascinated you, the full opinion is readable, even if you're not a lawyer. Look up Andy Warhol Foundation versus Goldsmith, 2023. There's a version of this video that's 40 hours long. I'm skipping the technical exceptions, the international treaties, the licensing structures, the compulsory licenses for cover songs, the entire world of trademark that people confuse with copyright every single day. If you become a lawyer, you'll spend years in those weeds. What I gave you today is the architecture, the skeleton that holds the whole thing up. Look, most people will go their entire lives creating copyrighted works every single day without understanding the system that protects them. And that's fine for most situations, but every now and then, someone gets a takedown notice or finds their photo on someone else's website or wonders whether they can use a clip in a school project. And in that moment, understanding the framework isn't academic. It's the difference between panic and clarity. If this video turns one person into the friend who actually knows how copyright works, the one people call when they get a weird email from a rights holder or when they're trying to figure out if they can use a song in their wedding video, then the whole thing was worth it. Because until 2016, a corporation was charging the entire world to sing a song that two kindergarten teachers wrote for their students in 1893. And for 80 years, nobody knew enough to say, wait, you don't own that. Now you do. This is education, not legal advice. If you face a real situation, talk to a licensed attorney in your state.